Well, hello, good afternoon, good morning, wherever you are. Welcome. My name is Carolyn Lee, principal and founder of Carolyn Lee Pllc, a U.S. investment immigration law firm dedicated to helping clients build their futures with investment immigration. Delighted to be here. Thank you all for joining me. Today, we're going to talk about EB-5 project structuring under the EB-5 Reform and Integrity Act of 2022, the RIA or RIA. I'm really excited and happy about talking about this topic. I've always enjoyed project structuring under the old law, under the new law. I think it has something to do with my background as a professional, starting out as a corporate transactional attorney. I feel like that's very much a part of my DNA as a person in the world, as a professional, and just have always enjoyed that and thought, oh, when I got into immigration, moving on to different phase of professional life, and EB-5 came back in, and it was this wonderful marriage of practice areas that I really love. So let's get started. Usually I just kind of talk with my guests. Today, because this is more informational, I'm going to share a presentation. And I'm excited about that as well. I think it'll be fun. So let me do a little screen share here. And I hope everyone can see this presentation. Now I'm going to try to go full screen. Sometimes this works, sometimes it doesn't. All right, it's not working, but just as well, you can see it, right? Okay, so we're going to be talking about EB-5 project structuring under RIA, and you'll notice my adorable Gantt chart on the bottom here, suggestive of what we're going to be talking about. Okay. All right, so disclaimer. This is informational only. It's not legal advice, certainly, and it does not create an attorney-client relationship, which can only be created with a formal engagement agreement signed by both parties. And so for good measure, let's call this attorney advertising as well. And then we'll throw in that this is also copyrighted. Okay, so about myself, that's me today, earlier, working away. I've just been fortunate, blessed, have enjoyed 17 years of practice and leadership in the bar, in the industry, in the EB-5 area. I think largely stemming from probably the combination of the commercial background and just being a geek and loving the complexities of it and writing about it and thinking about it and talking about it. 6-term chair, co-chair, vice chair of the American Immigration Lawyers National EB-5 Committee in recognition. Thank you, AILA. I'll be seeing my AILA colleagues in just a couple of days in Orlando, Florida. I serve as legislative counsel to Invest in the USA, or IIUSA, the premier EB-5 industry trade association. Very proud to serve in that capacity, leading to the passage of RIA. Thank you, ladies and gentlemen. I also serve as IIUSA's co-chair of the Public Policy Committee, where we continue to cogitate, analyze, write to the agency about EB-5 policy. Particularly, we're focused this year on RIA implementation, right? In terms of representation, I've represented U.S. project clients in their successful raise of over $2.5 billion in EB-5 capital. And I've advised many of those same clients in placing about 360 million, above 360 million in EB-5 redeployed capital. And by place, I don't mean from a corporate or securities or business standpoint, but from an immigration compliance advising standpoint. Okay, I should say redeployment is controversial in more ways than one. So I'll just throw in here that I've always taken the position, which I still hold, that USCIS's redeployment policy is not well founded in the law of EB-5 investments and investments at risk. Nevertheless, it appears here to stay. Okay, so let's get into this EB-5 project structuring preparation process. All right, love that graphic. Okay. So getting to the starting line, the preliminaries, I think this is very, very, very important. I advise attorneys and projects that have gotten underway, gotten investors, filed investors' cases, and are faced with a nasty notice of intent to deny or a very complex RFE or request for evidence from USCIS. And I would say the vast majority of those instances arise, in my view, from a lack of very, very careful preparation at the outset. Could have been avoided. So these are some of the elements that I think we'll need to really get a firm handle on out of the gate. One, control. Got to have control over the asset that is the subject of the project. So for example, real property, developing real property, you got to own it. You've got to have the rights to do what you want to do with it. So we are not even at like having acquired the asset stage. You don't have control over the asset too early. We can start advising, but it's not ready to be papered, submitted for investors to start coming in. Scope. We've got to have a firm handle on the scope. What is it that we're doing? How much is it going to cost? Do we have the other financing pieces in place? Because of course we can't rely on EB-5 capital all coming in and at the amount that we're hoping to raise. So we want those other pieces in place, and we want them firm. And we, again, using real estate development as an example, because it is so prevalent as a use in EB-5, is it ground break ready? Is the capital in place? Do we have a plan for how we're going to finance all of this? Do we have all the permits? Do we have the contractors lined up? And the closer we are to being able to break ground, the more ready it is for prime time, for filing, for setting up for favorable USCIS adjudication, which is going to be great for your investors. The further away we are, the more risk, because things can move around, then we have change. When we have change, we may have material change. And that is a risky thing to happen when USCIS issues an RFE and finds that they've taken pictures from Google Maps or they've searched public records and they see that what you're doing is not what you said you would do initially. Okay, so step one, take me to T. First thing, we've got to know where the site is, where that asset is, and that is going to inform whether or not that site qualifies as a targeted employment area, or as one of my clients calls it, T. The TEA is, of course, it's essential. It's the starting point of analysis in evaluating feasibility of an EB-5 project, the contours of it. It always was. It remains so today under RIA. Now, the TEA requirements have changed. This was one of the major reform elements that members of Congress seeking reform of the program wanted to make sure happen and it did, and indeed it did. So the rural, we've got 3 different flavors of TEAs or TEA treatment in terms of projects qualifying at the lower investment threshold for investor investments. We've got rural, as we always have. We have high unemployment, as we always have, but with different contours. And we have an entirely new category of infrastructure projects. Rural, I'm not going to talk about too much. The definition is the same. We talk about it a lot in other contexts, especially in our discussion of visa numbers and set-asides, because rural has the lion's share of the 32% set-asides of the total EB-5 numbers allocated annually. But in terms of the definition of the TEA, it's the same. High unemployment area. So the basic definition is that a high unemployment area, TEA, is an area that has 150% of the national unemployment rate. That part is the same. The contours have changed. The contours used to be any configuration as long as it's contiguous. This is what certain members of Congress objected to. So now it's all reined in, it's brought in. It's the project site where the new commercial enterprise or the job creating entity is principally doing business. It does not have to be a single census tract itself. It can occupy multiple, though contiguous, census tracts, plus 1 adjacent census tract. Very different. That's the high unemployment area definition. Of course, another change under RIA is that the states are out. States no longer have a role in designating high unemployment areas. It's all at the Fed level. It's all with USCIS. So we're not going in there with a predetermination from the states that, of course, USCIS did challenge from time to time. It's going to be all with DHS, with USCIS, with the I-956F adjudication. The third category, which is new, infrastructure. The key point here is that it's about government entity participation. That is an essential element. It's got to have a governmental entity that is the job creating entity. That's often the borrower. And it could be any governmental entity. It could be federal, state, local. And it has to be in a use that's toward a public works project. So that's infrastructure. Okay. So is the site a TEA? Step 2, regional center, anyone? Well, we need a regional center. We're talking about regional center project structuring. So this is where the bearing settlement would come in. And I invite you to read my article that I posted on the website, on my website, just for you today. And for kicks and giggles, let's see if this will take us. Voila, it's right here. And those of you who are participating will get a copy of the presentation with these links. So let's just kind of walk through this. So we had the Reform and Integrity Act, RIA, pass March 15, 2022. And one of the unexpected things that happened first was USCIS taking the position that RIA deauthorized the previously approved regional centers. And so if those regional centers wanted to do business again, they would have to seek recertification under the RIA before doing anything. Shocker. And so given that we have a 5-year reauthorization, and given that the USCIS takes years, according to its own reported processing times, to adjudicate EB-5 benefits applications, this was obviously an untenable interpretation. So there was a lawsuit filed by regional centers, where IIUSA also appeared as a party. And as a result of that litigation, there was a settlement agreement. Now, this is very, very important for those of us in this space to understand and to know about. What are the key terms of this settlement agreement? 1, previously approved regional centers are not decertified. You're still in business. You have to take an additional action. You've got to file the new I-956. And under the settlement agreement, you had to do that. The regional center had to do that by December 29th of 2022. That deadline has since been extended. So we don't have a deadline as of this moment. But eventually, regional centers, previously approved regional centers that are still certified and can operate today, will eventually have to file the 956 to come in line with RIA's requirements. Settlement term 2. Previously approved regional centers may immediately file project applications. So we know that we have to file a 956F form, which is the equivalent, the analog of the exemplar, the 924 exemplar application under the old law. We know that under the new law, the 956F is mandatory. Under the old law, it was not. So what can we do? Can we file 956F even though we haven't yet filed the 956? The answer is yes. Yes, you can. In a nutshell. Now, one thing here is under RIA, investors, EB-5 investors, no longer have to file their petitions with the project documents, each and every one, like a few hundred pages of their 526 petition being taken up with the same set of project documents. Thankfully, we don't have that. However, investors must file with proof of association with their project. And how do you do that? You, first of all, write it in your 526E petition if you're an investor, but you also have to, as an investor, include proof that the I-956F has been duly filed. And what's proof of that? We're going to get into it. The settlement tells us that we don't have to wait for that receipt, that formal receipt. We can use alternate proof that we'll have in hand earlier than a formal receipt. So that's good. Previously approved regional centers, let's call them parks, will be governed by the Integrity Act. Yes. So previously approved regional centers that are seeking to do business under the RIA, sponsoring new projects, affiliating with new investors, seeking new investors, sponsoring new investors, you will be subject to and be governed by the RIA. This includes persons involved with regional centers. There's a whole section in the RIA dealing with persons involved with regional centers, NCEs and JCEs. You've got to meet the bona fide requirements for being a good actor. And you establish that you meet those requirements by filing the 956H form. So you've got to do that if you're seeking, as a regional center, seeking to operate under the RIA. Now, that may sound obvious. Well, of course, if I'm going to be a regional center and operating under post RIA world, I've got to come under the RIA. Actually, this area has a number of open questions embedded within it, mainly dealing with regional centers that are not looking for new investors, but who still have old investors who are not through the multi-year immigration process to completion yet. Well, what about them? What are they supposed to do? They're not seeking to raise additional funds. They're not seeking to sponsor additional projects. They're not seeking new investors under the RIA. So what are they to do? Are they supposed to file the 956 or no? Are they supposed to file the annual report, the 956G, or no? Are they supposed to pay the integrity fee or no? We don't have really good answers to these questions yet. There have been some discussions, lots of discussions. There was a statement made at the last stakeholders call about which there's disagreement. Do we, on the integrity fee, do regional centers that are not sponsoring new projects or new investors have to pay the integrity fee? So we need some clarification here with respect to what these retiring regional centers need to do to comply with RIA to keep their investors' processes going, and what filings, if any, they need to submit. Okay, so let's go back. All right, step 3, show me the jobs. We have some changes here as well. We have the indirect job creation methodologies. That part hasn't changed, but we have a change in the way we calculate the total job creation. And it turns on whether or not the project, if it involves construction of at least 2 years or not. If the project involves construction of at least 2 years, it's fairly simple. Relatively, it's a two-step process. It's the 90-10, as I'm going to call it. You have to satisfy the job creation, 90% of which can be satisfied with indirect job creation. 10%, at least 10% of the required job creation must be satisfied with direct jobs. Direct jobs not meaning head counts. They can be mathematically derived, model derived with those valid economic job creation methodologies, but it has to be at least 10% direct. So 90% indirect is the max, it's the ceiling of the required, and then the rest will have to come in from the directs. So you can see that the cushion is going to come from the direct count. A little more complicated if the construction period is under 24 months. It's an additional step involved. So in that scenario, the max of indirect job creation is 75% of the required total, no more than that. So where do we get the addition? Where do we get that 25% minimum? It's got to be direct, but you can't just pull it down from the direct portion of your total job creation count. There is another step involved. You take your direct jobs that you need, the minimum, and then you have to apply a little side formula to it. You have to multiply that number by a fractal, which is the number, easiest way to think about it is the number of months of construction that it's under 24, over 24. So it's a fraction of the base, which is 24 months construction. And you take the construction related direct jobs, you multiply that, and that number has got to be at least 25% of the jobs that you need for that project, if it's a project that's got construction under 24 months. I don't want to get too much more into the weeds here, but a question is, well, what do I have to zhuzh through that fractal part of the formula? Is it all of my jobs, all of my direct jobs, including operations, if it has an operational component, or is it just the construction related jobs? So Arguably, it's only the construction-related jobs, but for projects that want to be very conservative, I've also seen all of the direct jobs judged through that fractal part of the formula. So you get a more conservative, you get a smaller number. But again, arguably, you would only need to do that with the construction-related jobs. Okay, so show me the jobs. Oops. There is a runner's theme here in case that's been missed. Just started with the steps and runners showed up, and I do enjoy a good run, so went with it. So step 4 of this is you got to state your business. You've got the business plan, we all know, is a critical, essential, very important part of the 956F, which is what we're talking about here, project filing under subparagraph F of the new 203B5 under RIA. Now you're going to see this runner is stepping on top of a rather large stack of paper that is suggestive of the matter of how compliant, comprehensive EB-5 business plan, which is required as ever under RIA. So we know what this is. It's got to state the feasibility of job creation, which is a simple enough proposition, but you've got to really prove it up. You've got to really, really persuade USCIS that these jobs are going to be there. And you do that with the plan of job creation. What is essentially what's the project about? Who are the key players? Who are the key entities? Where is this, of course? And there's a large stack of appendices or exhibits attached to this business plan, mostly in the form of fully executed agreements with all of the contractors, suppliers, other entities involved that will assure USCIS that this project will get underway if it already isn't underway, and it'll be completed because it's very, very well thought out, very well cooked. It has started, or the start is imminent, and all of the pieces of this complex puzzle are in place. We're not looking to fill gaps here. No gaps, all there. And that is what the comprehensive EB-5 Matter Code business plan is going to seek to establish in all instances. Step 5, this is Benjamin Franklin, who I sort of associate with solidity, principle, prudence. You've got to engage fund administrator with exceptions. So this is new. This is subparagraph Q under RIA, under 203B5 as amended by RIA. And there's got to be more, there's got to be controls over the movement, over the funds movement through the process from investment to funding, to the funding of the job creating entity. Couple of key principles. There's got to be a separate account. Can't be commingled with other projects. And there's got to be the fund administrator, except that there are exceptions. The fund administrator requirement can be waived if there is an affiliation with a registered broker dealer, or if there is audited financials of the new commercial enterprise. Okay. Step 6, we have to think about who's in charge here. As mentioned, we're going to be filing a 956H that establishes that the key people, people who have substantive authority over regional center operations or the NCE or affiliated JCE, meet the subparagraph H bona fide or bona fides requirements. And so that is going to be set out in a separate form that's filed with the 956F, the 956H. Step 7. This is my attempt at alliteration. We've got to document everything, of course. Dotted lines, we want to have everything in place. Everything's got to be signed and final, executed. If you're affiliating with a regional center, that affiliation agreement's got to be all signed up. The transactional documents underneath, the loans, everything. Of course, the NCE related documents, the partnership or operating agreement, all of that has got to be signed up. And everything's got to be disclosed per usual, except that we are going to be asked specific questions to make sure that there have been specific disclosures required under the RIA made in that private placement memorandum, PPM, or OM. And these questions will be asked right on the 956F form. Have all of the material risks been disclosed, including things like litigation, bankruptcy? Are there conflicts of interest? Are there fees that will be paid to promoters? Are those duly disclosed? And we'll be asked to point to where those disclosures are in the PPM, in the disclosure document. So all of that. Okay, so those are the ingredients. Now we get to the production process. So this is where really our work comes in, my firm, is immigration lawyers generally. It's about the form, right? So we are putting together the form and its required elements. The 956F form is what we're talking about. And it's a long form. It's a 17-pager. And it's very, very different from the prior iterations of the 924 and the regional center forms that we have had since whatever it is, 2011 or so. And I must commend the service on this form, actually, and it'll continue to be tweaked and evolve. Okay, we've just had a recent iteration of the form that was released just a couple of months ago, and it is still in draft form, if you will. It's at the interim stage, and the service is taking comments, and so it could go through other rounds of revisions before there is notice and comment issued formally about these forms. This form is, I'm calling it's 17 pages of aggregated RIA because it pulls together all of the requirements of the RIA. It just hits them. So we've got to provide information about the regional center. We've got to provide information about the new commercial enterprise. We've got to provide information about the JCE, about the job creating entity. We've never had to do that before. We've got to provide information about the TEA, and what kind of a TEA it is, how it qualifies, what are the NAICS codes, the industries involved in job creation, what's the total job creation count that's being claimed, where are they coming from which industry sectors. Of course, it's going to ask about the persons involved with, who are they, what are they, how are they participating, in what percentage, in what capacities, how many 956Hs are going to be filed, what about the fund administrator, who's that, are they in place? So it's all of the things that we just talked about. The form is asking about them. So good job, USCIS. It takes a village. The new RIA process, it's always been about collaboration, right? Even under the old law, we always needed corporate securities counsel. We always needed economists. We always needed business plan writers. Now, some of that, some regional centers and projects had some of those capabilities in-house, but point is, we're braiding in these specialized professionals. That hasn't changed. And my experience so far is, and it's not going to change, is that it's an even more intense collaboration under the RIA. Look at the form. The form is requiring in specific detail things like, where are these disclosures? How are the owners and the managers participating? This is information that we are going to want specifically, clearly, correctly represented in the form. And to do that comfortably, we need the collaboration of these other professionals. So it really does take a village to do this right. Filing and proof. So this is, we touched on with the discussion of the settlement agreement. We need proof of that 956F filing. So thankfully, this was an issue early on with the very first case. I'm going to take the credit. I believe my 526E for my client was the first one filed under the RIA. There was a question about that 956F receipt that we know needs to be included with the 526E petition, with the investor petition. Thankfully, the settlement agreement disposes of that question. We don't need to wait for that formal receipt per se. It can be alternate forms of proof, things like proof of mailing, proof of the cashed form of payment, plus at least the first few pages of the 956F itself. I include the entire thing. Why not? Investors and the 526E, we talked about this. So thankfully, now this is a result of advocacy over the years. It's very interesting how some of these points will percolate up and at some future point in time will bear fruit. This was a point that we advocates in EB-5 talked about for years. I mean, do you really have to have the project set of documents with each and every investor petition? We know they're uniform. And here we go. RIA says no. So that's an interesting side note there. So, but we do need proof of that 956F filing with the 526. So here are our contact details and my lovely social media icons down below. And I'm going to pause. I don't want to spend too much more time, but I will pause and take some questions if there are any. If there are no questions here, please feel free to reach out with your questions to contact at, and we'll be sure to respond and get back to you in some form because you're here. All right. Great. I don't think we have questions. Let me just cut on my thing. Okay, great. Well, folks, thank you for joining me. Oh, there's okay. Hello, hello. Suzanne looks forward to the entire webinar being made available. Thank you. Thank you very much. And thank you for joining me, and we will see you soon. Take care.